My connection to the music has to do with this thing here from my paper. Remember, this is what the musical people tend to use. And it has to do with my title and the whole presentation, because I will indulge into one specific genre of musical composition, namely variations on a theme. So what I will talk about is 9 variations on a theme by David Sciulli, Transnational Societal Constitutionalism. Ubi societas, ibi constitutio. This is a variation of Grotius, ubi societas, ibi jus. So wherever in society certain social formations develop, be these the great function systems like the economy, science, formal organizations or transnational regimes, all these formations give rise to their own constitution. This is a fundamental challenge against the claim of state constitutions. They assume a monopoly of all constitutionality. So for instance, the World Trade Organization, the governance of the Internet, ICANN, hybrid transnational regimes, for example, global health, the lex mercatoria, which is the contract law of the multinationals. They illustrate all in a striking manner how transnational regimes have begun to develop their constitutions, constitutional structures of their own. So constitutionalization beyond the nation state, as you said, can be observed as an evolutionary process which leads into 2 quite different directions. One, constitutions evolve in transnational political processes outside the nation state. Second, simultaneously, constitutions evolve outside international politics in global societies' private sectors. So not only the Kamnickel-Verein, but also things like the Lex Mercatoria. So what, however, this is my question today, is the specifical societal about this societal constitutionalism? And this question is currently the object of a controversy regarding the subjects of non-state constitutions, their origin, their legitimation, their scope, and their internal structures. But instead of taking side in this controversy, it might be more fruitful to interpret this controversy not as a conflict between incompatible positions, rather as a theme with a number of variations. And I will ask these variations 3 questions. So what is the distinctive compositional principle in each particular variation? Secondly, what are their shortcomings, their problems? And thirdly, what is most valuable in them, which should be maintained and reserved for the development of something substantive. So first, the theme. David Sciulli. David Sciulli is a sociologist, Italo-American, and he has developed this very concept of societal constitutionalism, and he was the first to develop a refined theory based on Max Weber. Max Weber's account of the dilemmata of rationalization in modern society. He tried to identify the existing forces that could counteract the large-scale evolutionary drift, which he thought was promoting increased authoritarianism in society, not only in politics, but especially in society. On his account, the only social dynamic which had effectively counteracted this drift in the past and which might be able to do this in the future was to be found in the institution of societal constitutionalism. And he gave especially importance to the social institutionalization of what he called collegial formations. For example, the professions, the university, so we would be part of this wonderful collegial formations, and other norm-producing deliberative institutions within society. So I begin with the first series of variations, extensions. Variation number 1, the long arm of the state constitution. Some theories attempt to interpret constitutions of various social sectors as expansions of the constitution of the state, even as part of the constitution of the state. For example, Rupert Scholz in Germany argued that the German constitution contained elements of not only of a political constitution, but of an economic constitution, of a cultural constitution, a constitution of the media, and the military, and an environmental constitution. And this was supposed to be imposed by the state to society, and was part of the political state constitution, and it was the task for public lawyers, constitutional lawyers, to develop specific norms and standards for the different types of the sub-constitutions of the state. In a somewhat different way, some other authors tried to explain the undeniable existence of transnational constitutionality by observing this as an expansion of state constitutions beyond national boundaries. So constitutional problems which appear outside nation states, for example, basic rights in the internet or the rule of law in transnational private arbitration, they can be resolved through the expansion of legal principles of the nation state. So I call these two versions of a constitutional statism, has to do with the state, which is extended to include societal constitutions, but I find them guilty of systematically undervaluing the self-constitutionalizing capacity of societal institutions. Their auto-constitutionalization can be explained theoretically through the dynamics of functional differentiation of society. In this process, function systems constitute themselves as they determine their own identity via elaborate semantics of self-explanation, reflection, and autonomy. So it's not the law that drives this process, but it's the social system themselves. There is, however, one aspect in the statist variation of societal constitutionalism which is of enduring value, and we should maintain it. They present the main historical model for other processes of constitutionalization. State constitutions have produced a rich reservoir of constitutional institutions, separation of powers, the legal state, democracy, basic rights, on which other sub-constitutions can rely through the course of their generalization and re-specification. So state constitutions serve as a model, most particularly because of a paradoxical achievement. They do not only constitute power and political processes, but they have been successful in effectively limiting, self-limiting the totalization of political power, which are immanent components of power processes by means of political power itself. So limit power by power. This is the constitutional principle. Variation number 2, the expansion of the political. Now not of the state, but of the political. Some sociologists, like Thornhill, explain the appearance of societal constitutions by the dissociations of politics and the state, by claiming that through the process of globalization, the political system has expanded beyond the realm of the state, both into the domain of international politics, but also into other spheres of world society. So he thinks that it is possible to empirically identify micro-constitutions in the pluralistic structure of world society, which formalize power processes within society, not in the state, within society, and which in reality are not constitutions of states, but constitutions of political power in society. Quite some subtle distinctions. So, ubi potestas, ibi constitutio. Ubi potestas. Where communication does not occur in the medium of power, society does not need a constitution. I don't agree with that. But where communication occurs in the medium of power, society invariably needs a constitution. So this is Thornhill. The problem with this is that it leads to a reductive position in which societal constitutions are only identified in political power processes. social power, not state power, but always its power. Outside this political systems, political process with both an institutionally and functionally distinctive character also take place in other social systems. And now comes the point. Their constitutionalization, however, does not only produce norm for power processes, take just the economy or take science or religion. On the contrary, it also creates norm for system-specific communication within partial systems, and their constitutionalization doesn't really depend if there's power or not. Of course, it is also there, but it depends on other processes of communication. Nonetheless, there is one motive in Thornhill's variation, and we should really retain it and develop it further, and this is the point of formalization of power. So he says the function of constitutions is the formalization of power. The power no longer is a kind of chaotic process, but something which is formalized as a medium of communication. And this formalization is the self-produced conditions for the positive and differentiated autonomy of power. Autonomy comes from this formalization. This requires greater generalization. Now comes my argument. Constitutions formalize not only power processes, but in general media of communication of very different kinds. It is not only the medium of power in politics which is constitutionally formalized, the media of money, of knowledge, of law, and information are also formalized in their own particular spheres of action through a series of sui generis constitutionalization processes. This is an important expansion of these ideas that one needs. If one thinks about social constitutions, one needs to by them to fight the power processes. No, this is much too narrow. Okay, variation number 3, rational choice everywhere. Economic constitutional theories, Buchanan for example, develop a more radical version of societal constitutionalism. They definitively decouple constitutions from the state, from politics, from power, or from international politics, and they view them as autonomous societal orders, especially in the case of economic organizations and markets. There's a narrower version, and there the constitution is applied to fundamental norms of genuinely economic action, but there's also a broader version which identifies constitutions in all societal group formations, including those of non-economic character, and it claims then that they all comply with the economic logic of rational choice. Obviously nonsense, right? So these concepts reflect the ubi utilitas, ubi utilitas ibi constitutio. So these concepts reflect an imperialistic expansion of a social system, the economic system, which also requires criticism. It is absolutely beyond doubt that any attempt to subordinate the internal structures of religion, of art, of information media, of love and family to the principles of economic constitution, or to judge these structures exclusively by principles of rational choice, which this would inflict intolerable violence both on the rationality of each systems in the Max Weber sense, because in Max Weber each of these different social spheres are gaining a kind of formal rationality, but which is different, is not economic, and on the basic orientation of society in its totality. Nonetheless, a valuable motive can also be discerned in economic theories of the Constitution. This can be found in their insistence that constitutions are manifest not only in legal political configurations, but also in the economy and in fact in all societal institutions. Variation number 4, summum ius. I forget what follows from summum ius. Remember summum ius, summa injuria, but I don't mean this now. So summum ius. There's a further variation, which is Neil Walker, and this attributes the societal constitution to the expansion, now not of the state, of power, not of the economy, but of the law, of the legal system, or more generally to the expansion of normative institutional sphere. This variation proceeds from a definition of institutions as ensemble of norms and it identifies sectorial constitutions in situations where legal orders are based are not based in the state, and they begin to institutionalize higher ranking norms. This institutional perspective is also deployed in international law, where people describe the emergence of higher ranked legal norms in the whole field of international law, in international organization, and in the so-called self-contained regimes as a form of constitutional pluralism beyond the state. However, this approach is also not unaffected by certain reductivist tendencies. A particular danger is that it is rather formalistically, rather almost Kelsenian, only looking to legal norms, both to norms centered around the state and norms of private ordering, and it neglects to address the social dynamics of constitutionalization, which impel the constitutionalization of society. The really important thing, in my opinion, is to observe the distinctive connection which emerges between hierarchies of norms in the law and processes of reflection in social systems. Nonetheless, institutionalism creates a valuable perspective, and we can identify more precisely the connection between a particular social system and the law, because when they speak about ensemble of norms, they do not only speak of legal norms, but also of societal norms, and they reflect, institutionalism reflects on this interrelation, and we could see this as a process of a two-directional translation between societal norms and legal norms. Okay, so these were the first four variations, and what we could say about them is that the compositional principle that underlies them is the idea that there is one single societal rationality which expands into all other sectors of society. It's the attempt to find a unifying principle of order in this unsettling multiplicity of societal constitutions, be this through the expansion of the political system, the expansion of the economic system, or of the legal system. These variations, however, are not able to appreciate the fact that the role of societal constitutionalism resides in the completely heterogeneous and mutually incompatible rationalities of different social spheres and their constitution. And at the same time, which then looks to their ability to limit their totalizing tendencies, which would they endanger each other. And all these theories are, in a sense, totalitarian theories. Now I come to my second series of variation, which has as a theme the unity of a global constitution. Variation number 5, the holistic constitution of society. They utilize a different compositional principle, the insoluble unity of the constitution. We find this in national constitutions. They have a holistic character. They make encompassing regulatory demands as a defining feature of constitutions. National constitutions are characterized by their integrative function for a fragmented society. Now, some theorists transfer these ideas to societal constitutions and look for the existence of a uniform constitutions, not only for the state, but for the whole society in its entirety, in some cases even for global society. In clear opposition to liberal constitutional that looks only at the constitutionalization of the political sphere. The historian Reinhard Koselleck claims that the age of the nation state was defined historically by the existence not only of the constitutions of the state, but of a more encompassing constitution for society, which also subjected economic, social, and cultural institutions to the requirements of constitutional law. No wonder that his teacher was working on the constitution of the medieval time. Matters relating to social questions had to be viewed as problems belonging to a genuine constitution of society, not of the state. If carried over into the process of transnationalization, he speaks about this, this construction would imply that the transnational corporations, their constitutions form part of a global constitution of all society. And we find in both international law and in political philosophy, like Fassbender, Höfes, also Habermas, claims that the constitutionalization of international law, which can be observed as a quite dynamic process, is able to create a cosmopolitical constitutional order, a uniform constitution for global society in its entirety. They see they don't speak about the world state, but they speak of the international community, whatever this community means, as the primary point of reference for an emergent body of global constitutional law. Now, it is quite obvious that such ideas of an encompassing global constitutions are hopelessly idealistic, and they are supported by pious hopes than by realistic analysis. Nonetheless, these cosmopolitan exaggerations also contain a valuable core, the idea of integration by institution, especially for fragmented societies. Societal constitutionalism certainly does need to address questions concerning the integration or the coordination of the plurality of diverse constitutional orders. Variation number 6, constitution as collective imagination. Now we move to culture and symbols. Some theories place their focus on the symbolic function of constitutions instead of their institutional reality, for example, vesting. Confronted with the undeniable plurality of public and private legal regimes, these theories cling nevertheless to the idea of the unity of the Constitution. But they reduce this unity to the idea that it only exists as a founding myth of a collective, be this a nation or the international community. Citation: in its symbolic dimension, the Constitution will assume a unitary character when it is dependent on a symbolically filled space, a cultural text which enables the Constitution normatively to cement a collective identity which overarches multiple processes of fragmentation. Feierliche Gesänge, right? This unitary constitution, which is merely fictitious, can be harmonized with the plurality of real successive sub-constitutions which are institutionalized in various spheres of society, but which constantly refer back to this founding myth of the unitary constitutions. Now, objection: it is very debatable whether a cultural text of this kind can be seen as a constitution in the strict sense, if it does not assume at the same time hard institutional form. But such a fictional theory of the Constitution rightly emphasizes that constitutions do not only produce positive law and resolve conflicts, but also create a narrative, an identity for a collective by means of a founding myth. Constitutions are in reality living processes in which a social system assumes an identity expressed in legal form. Now we move to the final movement, Unitas Multiplex. So in these concluding sections, I will produce 3 further variations on Sciulli's themes, and they are intended to bring together and developing further those motives heard in the previous variations which have proved to be of value. Variation number 7, meta-constitution. Meta-constitution. So the variations in the second group, they emphasize that it's precisely constitutional pluralism that gives rise both empirically and normatively to the question of a constitutional unity. Does pluralism only amount to a series of unrelated constitutions, or does it in fact, in one form or the other, produce constitutional unity specifically for global society? And my answer is Trans-constitutionalism. I steal this from Neves, but I give it another meaning. Trans-constitutionalism. Trans in the sense of trans and also... So trans-constitutionalism might potentially form an outlook which is both realistic and normatively challenging. However, in clear distinctions from Neves' concepts, this position needs to combine the following four elements. First element, a uniform global constitution which is indeed emerging, formed, however, only as a meta-constitution. So in the plurality of different sub-constitutions within global society, there's a meta-constitution. Second, this meta-constitution does not impose substantial constitutional principles, but projects exclusively procedural rules for resolving the conflicts between partial societal constitutions. More importantly, the meta-constitution is not constituted hierarchically in a freestanding institution, does not have judges, does not have an organization, which would resolve conflicts from the position of a third instance, standing above the conflicting sub-constitutions. Rather, it resolves these conflicts heterarchically, therefore heterarchically, through the decisions of these partial constitutions themselves. Fourth element, these decisions are realized either in acts of cooperation or negotiation, or in conflict, developing rules for resolving these conflicts, which are developed not outside, but within the partial constitutions themselves. So this would be trans-constitutionalism in this double sense of being beyond the partial constitution, but also going through them, and not creating a third instance. So these tendencies toward the emergence of a conflict of law constitution, and the lawyers will hear allusions to private international law, can be empirically observed in the infamous war of judges. Remember European Court versus Bundesverfassungsgericht, and remember WTO, free trade and regulation, health, and so on and so on. So what one finds here, there is a judicial dialogue. It's a war, right? And there is not a third party, not a third instance, but the courts themselves, among themselves, dealing with these matters. They react to each other, and from time to time they adopt arguments of other courts. So historically, a transnational meta-constitutions of this kind can build off the tradition of private international law, which deals with the conflicts between different national legal orders. And here we are dealing with conflicts, not national orders, but transnational orders and of a functional character. So again, there in this century-old tradition, without the presence of a third instance, the implicated legal orders have developed a large number of conflict rules for themselves. They were judges in their own trial. Each conflicting normative order created also the collision rules, and it's an object of intense discussion today whether the potential of international private law can be used for constitutional conflicts and modified to fit a novel historical situation of the conflict of transnational constitutions. And here it is important to reformulate two opposing principles of international private law: mutual recognition and ordre public, for the relation between the constitutions. They need to realize constitutional responsiveness, not only constitutional tolerance, as Joe Weiler said, but constitutional responsiveness, and to develop substantive rules which resolve the requirements of conflicting constitutions by establishing a compromise. And then the ordre public, the transnational ordre public, deals with the relation of the sub-constitution to the entire society. Each of the implicated constitutions constructs an ordre public, transnational law, from its own perspective. It doesn't exist. It is something which will be invented or is going to be invented in the process of these conflicts, and each transnational regime becomes responsible for constructing from its own perspective principles of an ordre public, transnational law, which encompasses all of society, that is, principles of a unified meta-constitutions in relation to which it evaluates its own norms. Now comes the penultimate variation, number 8, nomos and narrative. So here we have these two motives, the unity of the Constitution and at the same time the fictitious quality of this unity. The fact that they claim common points of reference in an abstract horizon of meaning to which they refer means that all partial constitutions can counterfactually project the existence of a unitary meta-constitutions. And this is the fictitious quality of this. For it's not factually given, but it needs to be developed. And insofar, you find in these partial constitutions a necessary relation to what we shall call the common good or the public interest, so that they do not just follow their partial rationality. Using categories influenced by Robert Cover, the Constitution contains a single nomos, but this generates a variety of narratives. And this captures the difficult relation between the institutional partial constitutions, they are real institutions, they have judges, they have organizations, they have money and all that, and the fictitious meta-constitution. Notably, this relation is not a two-level structure, but rather a process of reciprocal interpenetration on one distinct level, on the level of partial constitutions. And it is not correct to view the fiction of unity as projecting substantial constitutional principles. The global meta-constitution does not extend beyond mere procedures and principle of conflict. And here we find the relation between nomos and narrative in all these different constitutions. On the level of partial constitution, each of them develops not only its own nomos, its own laws, but also a whole narrative, a whole culture. Even the tough and cold lex mercatoria has its old founding myth and so on. Right? So there we have in each partial constitution a relation between nomos and narrative, but this is also repeated on the meta level, and the narrative of the meta level is integration. Variation number 9, my last one, which is called self-subversion. Self-subversion. So here we come to the inner core of the constitutions, and this is Thornhill's principles of the Constitution as formalization of the medium of communication, as the defining criteria for constitutions. Formalization of a medium. That means that a constitution is produced not only by a cognitive and normative reflection process, but by medial reflection, which means a medium is applied to itself. Form is articulated self-reference. The reflexivity of a medium means that media-oriented operations are themselves applied to the medium. In politics, this means the application of power to power. This is the moment where constitutions begin, when power begins to organize power processes. In law, it means the application of legal norms to legal norms, secondary rules. In the economy, this means the application of monetary operations to monetary operations. The central banks are doing that, right? They don't govern by force rules, they govern by monetary operations on monetary operations. In science, this means the application of epistemic operations to epistemic operations. This is how the autonomy of science is founded. Right? So, constitutions are defined or produced by this type of formalization, that a medium of communication is applied to itself. This formalization has constitutive consequences. I'm finished very soon. And paradoxically, it has self-limiting, even self-subverting consequences. And this paradoxical effect of medial reflexivity is what is important in late modernity, when the negative consequences of functional differentiation become visible, particularly in today's ecological crisis. If the damaging consequences of the expansion of power, this is what we know from totalitarianism and from constitution, all that. Expansion of power, but also from the expansion of money, expansion of technologies and law, are to be limited, a particular characteristic of medial reflexivity its capacity for self-subversion will play a central role. And this is rather unusual when we speak about constitutions which are entrenched, right, which are the symbol of stability and eternity and all this. But the constitutions also contain subversive practices. They work towards their own self-transcendence, a fact which is neglected in more orthodox constitutional theory. Medial reflexivity in constitutions operates as an internal subversive force with which a social system protests against its closure. This is the real sense of the famous Ackermann constitutional moments. They emerge when a potentially catastrophic development begins and transformative societal forces are mobilized which reach such intensity that the inner constitution of a social system transforms itself under pressure. Reflexivity protests against natural tendencies in social systems to recursiveness, routine, security, stability, authority, and tradition. And against such inbuilt tendency to orderly self-continuation, reflexivity infuses into the order a tendencies toward disorder, deviation, variability, and change. The Constitution protests against itself in the name of society, people, and nature, but does not so from outside, but from within, from the inner constitution of the social system itself. The paradoxical effect of medial reflexivity is one of the most important messages that a sociology of constitutions has to relate. It criticizes a tendencies of some theorists, but especially also of constitutional lawyers, which is becoming increasingly pronounced in transnational relation. Namely, they assume that both political and societal constitutionalism can be exclusively conducted by the law, and by contrast to marginalize the contribution of society. And they say that transnational processes of trans-constitutionalization and their protagonists are no longer collective social actors, but legal instances, constitutional courts, national courts, transnational arbitration tribunals. They suggest that the classical sources of the pouvoir constituant, social revolutions, upheavals, constituent assemblies now play an almost non-existent role. In somewhat exaggerated form, the thesis is from demos to rights. This, however, in my opinion, is a highly problematic tendency. I come to the end. The constitutive and limiting functions of a constitution cannot be performed by legal norms alone. They are performed primarily by the reflexivity of media of social communication. Courts cannot create living constitutions by command. The law only acquires a subsidiary impact in this regard, as it supports reflexivity in societal institutions. Its role is to institutionalize reflexivity in diverse social systems, which is thus by prescribing procedures of self-limitation. Both politics and social movements, which seek to use constitutionalization by law in order to combat destructive tendencies in the economy, in the technology, in medicine, or in the new media of information, they have to take into account this limited potential of law. They will not be able to realize the desired implementation of these systems by means of external legal intervention. The best the courts can achieve for societal constitutions is to create learning pressures for social systems. They can induce them in salutary fashion into self-subversion. Thank you very much for your attention.